How do I make a change to my trust? This is a question we get all the time. Hi, my name is Mike Rutkowski, estate planning, elder law, and asset protection attorney at the Rutkowski law firm. So there's a couple ways to do a change to your trust. Let's start with the how shouldn't I do it? And the first thing that we see so often is just an individual crossing off and initialing or writing in changes. That's not technically at all going to work. So we can't do it that way. There's actually a legal format for how a change needs to be made, and that's typically either what's called a restatement or an amendment. And so depending on the change that we're going to be making dictates what form we use to make the change. Let's just give some examples. We want to change the ages at which we distribute to our beneficiaries. We might be able to accomplish that through an amendment, which is just a couple-page document. It references the section that's going to be changed, the authority to make the change, and what the changes are. That has formalities as to the legality of it, meaning notarized, witnessed, all those things. Every state is a little bit different, so I don't want to give too much direction there, but it has to go through the normal procedures to be executed. The other thing we could do is a restatement. A restatement can be done when there's more significant changes. A good example of this might be we're completely reworking the beneficiary section. So instead of just changing some simple percentages, now we have a bunch of different people that are going to be distributed in a bunch of different ways. Maybe we're changing also who the trustees are of the trust, or there's a update in the law that requires an entire section modified. So depending on the amount of changes will usually dictate the difference between a restatement or an amendment. And so make sure that you're changing the trust the proper way. Another question along these lines that we get asked is how often should I be reviewing my trust? The typical answer is about every 5 years, but again, it depends on changes in the law, changes in your circumstances, like your kids are getting older or you have different assets now that require different provisions. I hope that was helpful. Again, Mike Rutkowski from the Rutkowski law firm, estate planning, asset protection, and elder law attorney. Give our office a call if you have any questions, 248-792-9193.